So, the United States District Court for the District of Columbia has ordered top US law enforcement agencies to release confidential information generated on President Bola Tinubu during a purported federal investigation in the 1990s. The judge, Barry Owe, who made the order on Tuesday, saying that protecting the information from public disclosure is neither logical nor plausible. So, an American, Aaron Grispan, had filed a suit in June 2023 under the Freedom of Information Act against the Executive Office for the U.S. Attorneys, Department of State, Federal Bureau of Investigation, Internal Revenue Service, Drug Enforcement Administration, and the Central Intelligence Agency. So, in his complaint, Mr. Grispan accused the law enforcement agencies of violating the FOIA by failing to release within the statutory time documents relating to the purported federal investigation into President Tinubu's and one Abiodun Agbela. Between 2022 and 2023, Mr. Grispan filed 12 FOIA requests with 6 different US government agencies and components seeking information about a joint investigation conducted by the FBI, IRS, DEA, and the US Attorney Office for the Northern District of Indiana and Northern District of Illinois. So, according to Mr. Grispan, the records being requested involve charging decision on the activities, including money laundering of a Chicago heroin ring that operated in the early 1990s. So, in each FOIA request, the Americans sought criminal investigative records about 4 named individuals allegedly associated with the drug ring: Bola Ahmed Tinubu, Lee Andrews Edwards, Muse Agbegboyaga Akande, and Abiodun Agbela. After the request, all 5 US agencies issued glamour responses refusing to confirm or deny whether the requested records exist. So, Mr. Grispan contested that responses at the Department of Justice Office of Information Policy, however, affirmed that the agency's refusal to confirm or deny the existence of the requested records. So, the American then filed a lawsuit on 12 June 2023, naming the FBI, DEA, IRS, and Department of State as defendants and challenging each agency response to the separate FIO request. Court documents show that the CIA was later added as a defendant in the first amended complaint, along with a challenge that the agency glamour response to the plaintiff FIO request. So, on 20th October 2023, Mr. Grispan filed an emergency motion seeking a hearing to compel the US agencies to immediately produce records responsive to the FIOA request. He cited the Nigerian Supreme Court's plan to begin hearing arguments in 3 days' time in a litigation contesting Mr. Tinubu's 2023 election as president of Nigeria. So, 3 days later, on 23rd October 2023, Mr. Grispan's emergency motion was denied for failing to satisfy any of the requirements for emergency injunctive relief. Also on the same day, President Tinubu moved to intervene in the case, citing his privacy interest in his confidential tax records and documents for federal law enforcement agencies that fall within the Privacy Act or exceptions of FIOA and should not be disclosed. So, in 1993, Mr. Tinubu was said to have forfeited $460,000 to the American government after authorities linked the funds to proceeds of narcotics trafficking. The issue of Tinubu forfeiture of the funds featured prominently at the Presidential Election Petition Court when his opponents Atiku Abubakar and Peter Obi challenged the president's eligibility to contest Nigeria's presidency, but the election court in an unanimous decision dismissed the suit, affirming Mr. Tinubu's election. However, on Tuesday, Judge Owe ruled partly in favor of Mr. Grispan in the US case. So, the judge noted that the glamour responses asserted by the FBI and DEA are improper and must be lifted. He said the FBI and DEA failed to show that they properly invoke FOIA. So, Mr. Owe said since it was acknowledged that Mr. Tinubu was a subject of an investigation involving both the FBI and DEA, the claim that the glamour responses was necessary to protect this information for public disclosure is at this point neither logical nor plausible. So, explaining his judgment further, Mr. Owe established that the FOIA requester must challenge the propriety of an agency glamour response in 2 ways. First, by challenging the agency assertion that confirming or denying the existence of any records would result in a cognizable harm under FOIA exemption, and second, showing that the agency has officially acknowledged otherwise exempt information through prior disclosure, meaning that the agency has waived its right to claim on exemption with respect to that information. So, in this case, the judge said that Mr. Grispan asserts both types of challenges to defendant glamour responses. The plaintiff argument that DEA has officially confirmed investigation of Agbela involvement in drug trafficking ring, and also the FBI and DEA have both officially confirmed investigations of Tinubu relating to drug trafficking ring, and also any privacy interest implicated by the FOIA request to the FBI and DEA for records about Tinubu are overcoming by the public interest in release of such information. Lastly, the CIA has officially acknowledged records responsive to plaintiff FOIA request about Tinubu. Meanwhile, the CIA has the judgment entitled in its favor in this case. The judge ruled that Mr. Greenspan has failed to show that the CIA has ever officially acknowledged the existence or non-existence of records responsive to its FOIA request. Therefore, the CIA glamour response must be sustained. So, during the hearing, the plaintiff agreed to narrow the issues for summary judgment, briefing the defendant glamour responses, redactions, and withholding as Mr. Tinubu and Mr. Agbela only. This is why in its judgment, the judge ordered that the remaining parties, apart from CIA, to file jointly by 2nd May a report on the status of any outstanding issues in this court as described in the accompanying order. So part of the document submitted by Mr. Greenspan to the court to back his FIO case was a verified complaint and accompanying affidavits filed in the Northern District of Illinois by the DOJ on 26 July 1993. The document sought the civil forfeiture of Mr. Tinubu's funds held by First Heritage Bank allegedly connected to the drug trafficking investigation. So the affidavit by Department of Treasury Internal Revenue Service Special Agent Kevin Moss, who was involved in the investigation, detailed the drug trafficking activities of Mr. Agbela, which provided the ground for seeking the forfeiture of Mr. Tinubu's funds. He also shared insight on how Mr. Agbela was arrested while selling white heroin to a person not known to him to be an undercover agent. He stated that upon arrival in the United States, Agbela identified Akande, who has also been linked to Mr. Tinubu, as his uncle, and stated that Akande provided him an apartment in Ormond, Indiana, citing investigation agent of DEA as the source of his information. Furthermore, he said according to DEA investigators, Mr. Agbela sold white heroin to another individual on numerous occasions. With the assistance of Source A, DEA called Mr. Agbela to purchase a small amount of white heroin, which resulted in a transaction where Agbela sold 1 ounce of white heroin to a law enforcement officer working in an undercover capacity. Subsequent to Issei, Agbela was arrested and agreed cooperate with the investigation. The affidavit also stated that further investigation by DEA disclosed a lease application completed by Mr. Agbela. So, Mr. Moore's affidavit confirmed that both the FBI and DEA investigated that Mr. Tinubu is the wider probe into the drug trafficking activities of Mr. Agbela and other members of his ring. It confirmed that there is a probable cause to believe that funds in certain bank accounts controlled by Bola Tinubu were involved in financial transactions in violation of US laws and represent proceeds of drug trafficking. It stated that seeking to target Mr. Tinubu funds arose from investigation of money laundering of the proceeds of heroin distribution organization in the Chicago area. So guys, that is it. I saw this news and I decided to share it with you guys, so please let me know your opinion in the comment section, and please help us by liking and sharing this video so that YouTube and Facebook can recommend it to more people. Thank you so much for your time and God bless you. Amen.